Well, delayed projects across the country, viewers, is an issue that we have been taking up very strongly here on Magicbricks Now, because people put their life savings into their homes, and when that home is never delivered, you're left with a home loan and a very disheartening court case. There are various builders across the country who have not delivered homes. If the court in Mumbai has appointed a receiver who will ensure that the building is completed, it sets a massive precedent for buyers across the country who no longer have to wait for RERA. They don't have to wait for anything else. They can cite this particular ruling, and they can also appeal to the courts for a judgment that is similar. We're talking about how this changes the fortune of several buyers across the country who are simply waiting for their homes. Our phone lines are open, and if you want to ask a question, if you're in a similar situation, you should pick up the phone and get in touch with us. Because in the studio with me today is Uday Wavikar, the Vice President of the Consumer Court Bar Association, Maharashtra and Goa. Also, Aditya Pratap is an advocate at the Bombay High Court. Also in the studio, Ramaswamy Krishnan is a home buyer at Kamla Landmarc. This is the case that we're discussing. Vishal Dasari is a home buyer at DB Ozone project in Dahisar, a case that we have been tracking for nearly a year. Dr. Colonel Kalra, who joins us from Gurgaon, is a home buyer, an aggrieved home buyer who bought a home from Unitech. Also a case that we've been tracking for a while. And then there are home buyers across the country who are welcome to join us right now. Uday Wavikar, I'm going to start with you. Landmark judgment from the Mumbai High Court changes everything for all of these home buyers and home buyers across the country. Tell us what this means for us as home buyers right now.
In a simple words, Kamla Landmarc has given a landmark, the Honorable High Court has given a landmark judgment. The difference between other judgments against the builders is where you are paid even to the extent of market value. That is what consumer courts are doing, or allotting some alternate flats if available. Here it is something else which is really trend setting, where the Honorable High Court has formed a committee and appointed a receiver to take over the entire property and directed the builder to pay for the development of the entire building, and the receiver as an administrator would work there to get the building completed with the other technical assistance. Is something really great, because now the flat purchaser, it seems, then they can take over and appoint, they themselves can develop or appoint some other builder in that place of first builder, and the builder who has taken the money has to repay it back. Faye will be now happy to note that the RERA 70%, how it is more important. Yes. Because the receiver will have a challenge now to recover this money for the purpose of
that was good. That was going to be my next question to you, Uday Wavikar. Yes. We've had cases, especially in the NCR region, where developers have just turned around and said, we don't have the money. So then the receiver, what does the receiver do in that case?
Receiver will have to then receive all his properties, assets, movable and immovable, auction them and collect the money. Otherwise, what is the other source? I mean, but of course, Kamla developers must be having a lot of other properties which are in their name, which they'll have to find out right now and act upon it to get it done. Because all the properties will be now attached, receiver can do that, apart from the property which is here. There is second option that receiver has is, if there is an increased TDR and FSI, then another builder can come in JV and then permission to sell a redeveloped building, and then he can book his profit, like it is happening, it was planned in Campacola. So similar way, because now the
right. So Uday Wavikar, and I'm going to bring in Aditya Pratap here. Basically, what buyers have been saying up till now is, even if you send the developer to jail, which we've seen happen in the NCR region, what does that do for me? It doesn't give me my home, it doesn't give me my money back. Now we're saying a receiver has been appointed by the High Court. This receiver will attempt to use the money that has already been collected. If that doesn't happen, he will attach the assets of the developer and make sure the money is made available to this one particular project. But Aditya, the buyers in this particular case took a different route. They didn't go to consumer court. They filed a civil case, didn't they?
Yes. They filed a civil suit in the Bombay High Court alleging a breach of contract and diversion of funds and all these things. And during the course of the hearing, it came to light that the developer had fabricated and forged the commencement certificate. This set in motion the criminal proceedings because it's an offence under Section 464 of the IPC, and cognizable non-bailable sections became involved. Furthermore, we also see that by pursuing the remedy of a civil suit, under the civil suit, the High Court has full powers to appoint a court receiver to take control of the project. And furthermore, it has set in place a mechanism which precedes RERA itself. We have a third party like an escrow, the court receiver who will come in, he'll collect all the monies, and real estate in Mumbai being so valuable, he will be able to expedite the development. Now there is one more point to be noted here in this case. In Mumbai, projects do not stall because of financial reasons, they stall because of violations of law. Even in the Kamla Landmarc case also, every builder after he receives a commencement certificate, he wants to suddenly change his plans. He wants to incorporate additional FSI, he wants to build more. The end result is your project ends up getting stalled. You have to get fresh plans approved. There may be environmental issues also involved. And as we see here, in this case, the developer had even fudged the CC by putting in a higher floor. So this problem that after builders get the commencement certificate, they simply later on change their plans, they don't lock the project in one go.
All right, I want to bring in the home buyers here one by one. I'll start with Mr. Ramaswamy Krishnan. Mr. Ramaswamy Krishnan, how does this, this is a victory for home buyers across the country, but for you in your particular case, how does this make you feel right now? Tell us the case so far and what you've experienced as a home buyer.
Well, as everybody says, it's a landmark judgment. It's because it is Justice Katawala. Now, having said that, now what are his assets? Now, this is something which needs to be pondered on, because most of the projects, what he has done is, he has done a booking of about 90 to 95%. So what is remaining? To go on a JV, he cannot go on a JV unless there is some additional FSI given. So I don't think, because every project, there is not one project, there are about 10, 12, 15 projects where he has done the same modus of operandi. He has taken buyers, like for example, Kamla Grandeur.
Yes.
There's around 400 bookings. So what do you do? I mean, what more can he sell from that project? And it is still unclear, and UOW is still working on it to find out whether that SRA, what is the status of the SRA project? Because it was an SRA project, whether have they sold it to somebody? Nobody knows that. So
this is the other question, Uday Wavikar, when buyers like this of other projects. So now this particular project that we are talking about, where we've received this landmark judgment from the High Court, gets a receiver appointed. What happens to the rest of the project? If the assets are attached to finish one project, what happens to the rest of the home buyers that this developer has sold to in other projects?
This is a very serious question, because if the other projects also, the attachment, therefore I was saying the attachment of the properties would be exclusive personal properties first. Because if you go on attaching the other properties, they cannot, because the land will be on somebody else's. There will be an agreement of development with the builder name, and that is the modus of operandi in Mumbai. The landlord doesn't sell the land outright to save the stamp duty. What landlord does is he gives the development right, takes entire money. The land does not get transferred in the name of builders. I am putting it in simple English. And then because it is not conveyed in the name of builders, because builder doesn't want to pay the stamp duty, only development rights are given to builder. The land still remains in the name of landlord.
Right. Right. I have Anil from Mumbai right now, who's on the phone line. Anil, go ahead. You're on the show. What would you like to say?
Yeah, I just wanted to know.
Go ahead, Anil.
Yeah, I just wanted to know why such a receiver would come up front and ask the builder, bear the brunt of the builders. And is it like an arbitrary person, or why are there any guidelines set for these arbitrators? I mean, these builders to to work with this kind of...
So basically, what Anil wants to know is who is a receiver and with what authority will he approach the builder? Aditya, do you want to take that question?
Well, the court receiver is an officer appointed under the Code of Civil Procedure and the Bombay High Court rules. He has the powers to take control over the project, ensure that all receivables which may come in from customers, from buyers, they will flow directly to the court receiver. And then the court receiver will ensure he may have a tendering system wherein a competent contractor, or if it's necessary to complete the construction, can be appointed to complete the task. And furthermore, it will also ensure greater transparency. And what the court, this judgment indeed is a remarkable step, because the Bombay High Court has directly, in one way, bought in the mechanism which the Real Estate Regulatory Act is proposing, that is to appoint a third person, either the authority or anyone, to take control of the project and ensure that everything goes well and ensure that there are also no fund diversions.
All right, so let's also bring in Dr. Colonel B. Kalra, who joins us from Gurgaon. Dr. Kalra, unfortunately, we always talk under these circumstances, and you've not received any relief at all in the case that you've been fighting for a very long time. Tell us what your experience has been with Unitech, what was the largest builder in this country when you bought from that builder?
Since 2009, when we booked the houses, we were told in 2 years we'll get the houses. Till to date, we have never got the houses. We are only getting or hearing promises, dates. And still, we have already paid over 93% of the cost. Not 1 or 2 or 10 or 20%. 93% of the cost has already been paid. And still we are without the house. Tell me, no roof above our head. They promised not once, several times, but we have still not got the homes. And
Dr. Kalra, tell us also what legal remedy you and the other buyers of this particular case have approached the court for. Have you gone to consumer court?
See, the central government passed the RERA Act or the bill, and it was notified way back in May 16. And
Yes.
within 6 months, the Haryana state was supposed to pass the rules. Unfortunately, it has not been done so far. The central government has done their bit. The state government, states like UP has done it. States like Gujarat has done it. Even union territories, Chandigarh, Andaman Nicobar, Lakshadweep,
Right.
Diva and Daman, they have all passed the RERA rules. Our Haryana state is still lagging. 6 months have been completed. We have got wonderful chief minister who is a dynamic, honest, hardworking chief minister. But I do not know where is the delay.
But tell us, Dr. Kalra, tell us what remedies you have approached the court for up till now. What has been the legal recourse that you've taken?
See, large number of us have gone to the consumer court, national consumer court. Some of us got relief from the consumer court. But then what happened? The builders, along with some fake buyers, fraudulently got one order passed, and a fake compromise formula was laid down that we all will agree we will not go to any court against the builder. Existing cases we will take back from the court so that the builder has enough money to build the houses. Tell me, if they have taken 93% of our money and still they are not ready to make the houses, that means the problem is somewhere else.
The problem is somewhere else. You're very right. Aditya Pratap, obviously they should now use a different route, given the fact that we now have a precedent here from the Bombay High Court.
See, in fact, let us come to the case of Gurgaon. In Delhi, in the NCR region, projects get delayed because of financial issues. And the most common reason is that developers tend to divert the funds. Now, when a customer pays an advance to a builder, it is effectively an entrustment of money under a contract. So if the builder diverts this money to another project, a direct case of criminal breach of trust under section 405 and 406 of the IPC can be made out. The benefits of this will be that if a police investigation is initiated, they'll have all the powers of search and seizure to ensure where this money has gone, where it was spent, and what were the wrongful gains. This will also bring in greater accountability and ensure that the truth comes to light.
Uday Wavikar, what advice would you give Dr. Colonel Kalra and the rest of the viewers who are facing similar problems?
I am little surprised. As Pratap has rightly pointed out, they can move High Court, and High Court has sweeping powers. Only as rightly pointed out by my friend Ram, you need honorable justice who has delivered the judgment really well, but you won't get katawalas everywhere. The point is delays, even in judiciary, causes a hurt. Consumer Protection Act is relatively faster. I am saying relatively faster. Even as Dr. Karla said, they have got the orders from Consumer Court. But then there was some agreement done by some buyers. I don't think this some buyers really affect to the consumers as long as they are not the parties. So they can file execution. They can attach the properties of the builder directly from Consumer Court under Section 25 and also send them to the jail under Section 27. Normally with this fear and attachment of ultimately what receiver is going to do, he is going to attach the properties and get the funds. Now the question is, with this new judgment,
All the BMWs and Lamborghinis.
yes. So the point is, how fast receiver will recover. In fact, there will be faster recovery through the consumer code under section 25 by attachment of properties and auctioning it and giving it to the consumer directly. But both the remedies are similar. The speed of the consumer courts are faster, and both you can do. You can put a builder to the jail as well as attach his properties and take the money. Thirdly, this new proposition, I think, can be moved under the Consumer Protection Act also, that if all the buyers to come together and they want the project to be taken over, and if it is feasible to be taken over, it can be taken over.
It can be taken over.
Yes.
In fact, Arvind Kumar Gupta is on the phone line from Noida with a question for us. Arvind Gupta, go ahead.
Hi. Sir, I'm right now in Calcutta. I've bought few flats, two at least. One is stuck up with the JP Group.
Yes.
This is in Wishtown Classic, where they have taken the money in, I think, January 2009 I booked it. I've already paid 90 to 95% of the money. And you know, JP are politically patronized, very close to Mayawati, or they say it's front of Mayawati also. So now nothing has happened in last 7 years. And I'm not the only one. Maybe at least around 30,000 people in different projects are stuck up. With some, I have taken on construction link payment basis, where I paid in parts. I have a friend who has taken his cash down payment. He paid almost this much, 40.
How much have you paid, Arvind Kumar Gupta? How much have you paid so far?
I have paid around 90 to 95%.
90 to 95%, and there's no home. We know that JP Wishtown is still delayed. Uday Wavikar, it's this sort of stories that I'm sure that the High Court is also reacting to, the fact that people put their life savings.
Totally.
And these developers in question, the ones that we're talking about, and I want to point out that the whole industry has not been this way, but we've had several cases who have, without conscience, collected 90 to 95% from buyers and given them nothing in return. It's high time that the law is allowed to take its course.
Faye, I totally agree. If you look at the MOFA in Maharashtra, it only allows to take 20% and not more than 20% amount without making a registered agreement, number one, without starting the project. At the booking, you have to pay only 20%, otherwise it's a criminal offence. You take 1 rupee also, you got to enter into an agreement, and RERA also reflects the same now. And therefore, these laws are coming in picture. But what is most important is, these people are so grievously affected, and I feel equity demands, even under the Consumer Protection Act, faster results to them. Today, in this case, High Court has put the cases on the fast track, but which is really required, especially even under Consumer Protection Act. You know, things are taking steps, but 5 years you require 3 to 5 years. And if you file in forum, then you go in, builder will go in appeal in the State Commission, then National Commission, and then Supreme Court. Therefore, the beauty of it is National Commission has come round now and passed a landmark judgment by Justice V.K. Jain that you can file a class action petition. All the consumers, even in this Calcutta case, can come together, as has come in Balaji's case in Mumbai. I have filed a case under with 235 people as one complaint and is getting admitted before the National Commission. So that it's a shortcut. All the people are together.
When someone files in National Commission, Uday Wavikar, you recommend that they cite the case of Shimmer for Kamla Landmarc.
Correct.
And say this is the judgment that was received in Bombay as well.
And if they could,
you wanted to say something?
Yes,
Go ahead.
I would like to ask my friend a simple question. Now, everybody knows what is a MOFA Act. MOFA was in place for many years. All our agreements, the payment is done 25% and the builder has not had a registered agreement. We all paid 25% and we are waiting. We kept on asking, following up, but he said wait, and that wait never came. It's 6 years now. And
So you don't have a registered agreement?
No, so now that's what I'm asking. Now, what about the police? Now, when they know that this is a criminal offense, what are they waiting for to arrest a person? Now, I have been running pillar to post for the last 4 months. My case has still not come up by the by EOW. They have not brought it up. So they are saying, okay, I'm not saying they're not doing their work, but they're, I'm losing my patience.
Just to add to Mr. Ramaswamy, in the Kamla Landmarc case, the progress has been fast because it is under direct instructions of the High Court. There are innumerable cases where FIRs are registered against builders, but the police absolutely does not take any action. They take 5 months, 6 months, 1 year, 2 years, and no charge sheet is filed, no report, nothing. And the main thing is to be seen whether had the High Court not been there in the Kamla Landmarc case, would the EOW have taken action?
Well, isn't it possible for me as an aggrieved home buyer to approach a magistrate or a court to appoint an investigative officer to look into a case if the police is not taking any action? Aditya Pratap?
Certainly. The first step is to register an FIR in the police station. But police usually does not register such FIRs. Then you give a notice to the commissioner under section 154(3) of the CRPC, and then you can directly approach the magistrate's court under section 156(3). The magistrate will peruse the complaint, see the documents, and if he is satisfied, he can instruct the police to register an FIR and investigate the matter. But yes, after the FIR is registered, the investigation becomes the total domain of the police. In this respect, the oversight is limited. The police regularly delay submitting reports for even charge sheets are not filed for 1 year, 2 years. Finally, only when then the parties end up either moving the magistrate again or moving the High Court for an expeditious investigation. So yes, the stand is clear. Had the High Court not been there, the outcome would have been a little different.
The outcome would have been a little different. Vishal Dasari, one second. Vishal Dasari is also in the studio, and Vishal's case, which is the DB Ozone case by DB Realty in Dahisar in Mumbai, is something that we've been tracking for a year on this channel, and it's a heartbreaking case, really, where these people bought homes and they've just been left high and dry. Vishal Dasari, has there been any update, any progress from the developer, who I know personally has constantly been making promises to you as home buyers?
Yeah, I mean, as you have rightly said that you have covered this thing, and there have been we have been updating you, but from the builder's end, there has been no progress at all. There is no significant work happening. For that matter, for the last couple of 2-3 months, there is absolutely no work happening at the site. So we, I mean, on the insistence of the chairman, Mr. Goenka, we had a formed group just to open a channel of communication between DB Realty and the buyers. And the chairman himself had committed that he will be starting all the work in full-fledged from 1st of November. But still there is no, the work has not started at all. Again, when the date comes, we get again a different date that it will be starting in 15 days. After the 15 day, again there is a different date which is committed. So our agony is never ending. We have tried to approach the police stations for registering FIRs. We have not found any success in that. The police are not registering.
The police are refusing to register FIRs in your case?
Correct.
Uday Wavikar, this is appalling. It is appalling. And what justification is there for the police to not file an FIR? What does this mean? That the police is being paid off by the developer in question? Why wouldn't the police file an FIR? Where in this particular case, 3,600 home buyers, not 100, not 200, 3,600 home buyers have been waiting for their homes for over 4 years, and there's been no movement on the ground. Why wouldn't the police file an FIR?
Faye, you have put in correct words, not more direct can anybody say. Honestly, the police, in fact, there was a circular taken out by Commissioner of Police that all the MOFA violations, statutory violations,
that you're allowed to file an FIR. But I mean, let's ask Vishal. Vishal, we talked about that circular when it came out. Has there been any difference in the local police station in Dahisar after that circular came out from the DGP?
No, I mean, when I had gone individually, they absolutely refused to entertain me. Then we had gone in around a group of 40-50 people. They've just taken some application from us about some case details, but there is no FIR registered. There is no FIR registered, or rather, we are not getting any feedback. We have been continuously following up with the Mira Road police station, but there is no update or there is no feedback from there. Apart from that, we have been continuously tweeting to the Chief Minister or various ministries, Housing Ministry and various ministries regarding this. The Chief Minister has, I mean, whenever a celebrity like Kapil Sharma is tweeting something, he has all the time and all the attention to provide to him. But when 3,000 of us, we have thousands of tweets we have directed to the Chief Minister, there is not a single response. There is nothing that which is coming our way. So we are just totally helpless. What should we be doing? On one hand, there is There is an agonizing wait. The builder
Absolutely.
is absolutely
And
not cooperating.
It's a piece by piece. The fact that, first of all, and I want to make this very clear, this particular developer, this DB Realty, we've contacted the developer repeatedly. The home buyers have contacted the developer repeatedly. All we get are fresh promises and fresh deadlines. But there is another construction that's happening in central Mumbai, right here, close to Lower Parel, which is an active construction site, which is being promoted by the developer, which means that you've not entirely run out of money. You have money, but for the projects that you think you can make a profit on. In the meantime, Uday Wavikar and Aditya Pratap, I'll ask you this question. If these buyers are unable to get an FIR filed, who should they go to? Can 3,600 buyers tomorrow go to the DGP's office and say, listen, your circular has not worked. The people who report to you are absolutely disobeying your circular. They are not filing an FIR for us. And we, 3,600 citizens of the state of Maharashtra, are being treated badly.
Well, that is a remedy of public pressure which should or should not work. As a lawyer, I would advise them to approach the court of the Metropolitan Magistrate under section 156(3) and ask for the FIR to be registered. After the FIR is registered, then they should approach the senior officers, the CP and the DGP, insisting that the police does a thorough job in investigating the matter, that they search the builder's premises, make the necessary arrests, and ensure that what has gone wrong, have the funds been diverted, any cheating has happened. That is the logical step to be taken.
If they're not getting any help from the police at this point, can't they just approach the High Court directly and file a case of cheating?
I'll just add to this.
Yes.
Well, in the High Court, they can file a civil suit and accuse the builder of breach of contract. They also have a remedy under the Maharashtra Ownership of Flats Act and also under the NCDRC. And if I may suggest a more radical remedy, since the Real Estate Regulatory Act has already been notified, but we have no RERA for the state of Maharashtra, nothing stops a person from from filing writ petition in the High Court and asking for a writ of mandamus to instruct the state to form a RERA within a certain time. And furthermore, all projects which have not received a completion certificate, they will come under the RERA banner, which I think should be very helpful for Mr.
But let's be honest about RERA. It's horribly delayed, Uday Wavikar.
Yes.
And we expected the deadline for states to complete their rules was the 1st of October.
True.
All of the states have missed that deadline. We are not seeing enough political intention from any of our state governments, Maharashtra included, in bringing about RERA. I want to understand what is the delay. If the central government had written the rules for the union territories months ago,
very good point.
What is the delay? Why are our state governments dealing? Why are our state governments in constant meetings with developer groups talking about the rules and not releasing the rules? The central government was very, very clear.
We must request all chief ministers, all these states, that they must pass the rules immediately.
The central government was very clear about the urgency of this regulation and how people desperately need it.
I definitely agree, Faye, with you. On the contrary, now the radical things are required. As Pratap has said, one must file a writ petition before Bombay High Court. Not only that, I think media and the public should also pressurize our Chief Minister and ask him. There are reasons.
Absolutely correct.
Reasons because once you interview Honorable Chief Minister or even interview Prime Minister to that extent that your guidelines are there, what is happening in states
6
which
months
are
have passed. 6 months was the deadline. It is already over.
Yes. Apart from that, Faye, what we have to do here is that Maharashtra government is in a typical dilemma on two ways. One is, as you rightly said, there must maybe a pressure from builders, we do not know. But what is more important is that there is a Maharashtra Flat Ownership Act and RERA which is contradicting, because the central RERA doesn't have provisions of deemed conveyance.
Uday Wavikar, those problems are all
could be sorted out.
Fair,
that is what
but there are legal teams in the government that can sort out those problems.
Faye, I'm coming there only.
They just need to make a decision and move on.
They can just make a blend because authorities have been given to them by the central RERA. And they can make a blend and take it straight away or keep both the acts
There's no
together.
excuse really for the Maharashtra government to have delayed their RERA rules this much. We've seen several states have come out with the RERA rules. What's going on with Maharashtra? Why can't we have our RERA rules when there are so many buyers who are struggling at this point?
I totally agree with you.
It's completely unfair. Dr. Prashant Singhal is on the phone line from Kolkata. Dr. Singhal, if you can hear me, go ahead.
Good evening, everybody.
Good evening.
Hello?
Yes.
Hello?
Yes, we can hear you. Go ahead.
Yeah, I am Dr. Prashant Singhal calling from Kolkata, and I have a similar case. Hello?
Yes, we can hear you. Go ahead.
Clear? Yes. Now, I had booked a flat in Green-Tech IT City, Vedic Village in Kolkata in 2014. And according to the rules, I pay 30% of the amount, that amounts to 24 lakh something, including the service tax to the government.
Right.
Now, till date, the builders have neither given me any agreement. I've been asking for it for a long time. They have only given me a Xerox copy to go through. Nor any of the persons come to meet me. Whenever I go to them, either they take me to the marketing agents, and the marketing agents tell me that go to the builders first. So the intention is quite clear.
Dr. Singhal, do you have any paperwork at all from the developer? A receipt, perhaps a brochure?
Yes. I have paid all the amount in check, and I have all the documents, including the allotment letter also. And I have sent them many emails asking refund of the money when I saw that there was zero construction till December 2015, and they were supposed to hand me over the flat in 2016.
What has the developer told you so far when you got in touch with the developer?
Oh, they said that the market is stagnant. We can't hand over the project now. It might be delayed by 3 or 4 years now. And the money cannot be refunded since there is no money, there is a lack of money with them. So then they also ask me, you can take whatever steps if you want. Unfortunately, the West Bengal government does not implement the new RERA Act, and there is definitely some nexus between these people. Otherwise, why would the West Bengal government not implement or so many states not implement the new RERA Act? That itself shows.
Right. You know, I also have Dr. Ghosh on the phone line right now, but Uday Wavikar, the excuse of the market is stagnant is not the home buyer's fault.
Absolutely.
The excuse of I have run out of cash is not the home buyer's fault. These are bad business decisions made specifically by bad developers. Dr. Ghosh is on the phone line from Kolkata as well. Dr. Ghosh, go ahead.
Yes, sir. Hello.
Yes, hello. We can hear you. Tell us what your problem is, sir.
Yes, I have purchased a flat in Kolkata.
Yes.
They have already given me position. On 22nd, they have given me the position. And they have given me the position letter also. It is written 1200 square feet flat.
Okay.
Now they are telling, after taking the position, now they are telling that your flat is 62 square feet extra and you need to pay extra money. Then I told, why you have not informed me earlier? After giving position, now you are telling 62 square feet extra. Now, 4th December, my registration, now they are sending always mail. You clear the extra money, then only your registration will be.
Who is the developer?
Yeah.
Tell us the name of the developer to caution other builders, to caution other buyers.
Siddha Group.
Siddha Group in Kolkata. The Siddha Group in Kolkata. Uday Wavikar.
Yes.
This is not allowed. You can't change your mind about the size of the home, whether more or less, and expect a buyer to pay.
In fact, the regulation says, I don't know in Calcutta whether there is any MOFA, we'll have to search, but otherwise also development control regulations and regulations say that without the consent of the buyer, you can't change the plan. Once you have sold a buyer of a particular size, and my advice to the honorable gentleman is, please take an architect and actually measure what is the carpet area. Because these builders sell the area which is much super built up area and not the carpet area which they call it as a sellable area. And if you really work out in the basis of actual area, carpet area, there is a 40% loading. So maybe all you know your flat is not even of the size that builder is saying. Plus they take the balconies inside, they take the servant quarters inside, they take all these niches inside, which is not correct. And therefore, if you really take an expert, you will find that your flat is less, your flat is of the lesser area. Here, it is an unfair trade practice. You can go to the consumer court that you tell one area, then demand.
I must tell you, there is a West Bengal Apartment Ownership Act of 1972 that can be used. We don't have to wait for RERA just yet. Most of our states have regulations. Aditya Pratap, I want to circle back to the problem that Dr. Prashant Singhal had brought up, the fact that the developers turning around and saying, there is a stagnant market and we have run out of cash and we can't deliver right now. That's not my problem as a home buyer. I paid you for a service that you are not completing because you managed your business badly. That amounts to a violation of the contract.
Yes. Now, in this, it is certainly a breach of contract, but there is more to it. See, why do projects get delayed and funds crunch is not the real reason? In cities like Mumbai, projects get delayed due to corruption and violation of laws, where builders keep trying to amend their plans and get more FSI. This leads to more complications. On the other hand, in places like Delhi and other cities, the funds issue is a problem, but then the point is that construction cost is negligible. Construction cost is only some 1,000 rupees per square foot. In fact, and with all the customer advances coming in, construction can easily be covered. On the other hand, the real story could be that several companies, as we've seen of big groups in the Delhi NCR, they tend to have huge land banks of thousands of acres. Moment they get customer advances, a portion of this money will go into purchasing more land. And then they will proudly claim, we have a land bank of 3,000 acres, we have a land bank of 5,000 acres. This tendency to divert customer monies into land speculation and purchasing more land banks with the hope that later on this land will appreciate, this leads to a major delay, and hence even a criminal investigation may be required that number one, project funds are diverted, number two, where they are diverted, so that those lands are taken hold of.
You know, I want to ask the home buyers in the studio right now about how disappointing this is. Vishal Dasari, to find out that you're not alone, people across the country are facing similar problems as you, and we've battled for error. We've battled for error outside of courts, outside of delayed projects, on television channels. We've demanded a regulator over and over again until the central government gave us RERA, and nothing has changed. Post so many months, from May till today, from the time the central government passed RERA in the Rajya Sabha, nothing has changed on the ground. These developers who are delaying projects are as brazen as they always were. I'll come to Colonel Kalra first and then Vishal Dasari. Colonel Kalra, is this disappointing for you as a home buyer?
Yeah, because some of the states are sleeping. They should have come out. The smaller states have come out with the law, the rules. Why can't Haryana come out with the rules? 6 months have already passed. Why can't other states do it? They must do it immediately. We are suffering because of their delay. The day the RERA rules are there, within 3 months, they are supposed to apply for the sanction for the project. And if they delay it beyond that, if they don't complete within the time, there is provision of punishment, including imprisonment.
Well, none of that is really come to pass because none of those rules are really active. Vishal Dasari, how does this make you feel to hear other people from across the country facing the similar problem, getting no reaction from the police, getting no reaction from governments? No one is stepping forward to the rescue of the home buyer.
Yeah, to say that it is disappointing would be an understatement. So this, you have regulators for mutual fund customers, you have regulators for telecom customers, but when we come to real estate, buying a house is perhaps a once in a lifetime thing for many of us. And for such a big, huge investment and for such a huge decision, we are left with absolutely no help from the government, from any of the authorities. There is nothing that we can approach to for such a critical decision or for such a critical thing of importance. We have, we are.
Who's going to come to our aid? Who is going to come to our aid? And you know, Vishal makes a very, very good point. Mutual funds. The minimum investment in a mutual fund is 500 rupees a month per investor. We have a regulator who pays a lot of attention to investor rights for 500 rupees a month as a minimum investment. We invest our entire life savings and everything we are going to earn for the next 20 years in a home with hope that our families will be able to live there, our children will grow up there, our parents will be able to be comfortable there, and this is what we get in return. And absolutely no change, no sort of empathy at all from our governments. This sort of treatment of us as citizens and home buyers is something we should vehemently object against. Bernadine Fernandez is on the phone line from Bandra. Bernadine, go ahead.
Hi, sir. Good evening. I had booked actually a flat in 2012 through the builders Monarch Universal at Roadpally, Navi Mumbai. Now every time I kept following up with them. I have done 100% payments. They kept giving me some reason or the other and refused to register my flat. Finally, after putting a lot of pressure and going to the police at Kharghar, they finally registered my flat last month. When I came in from my work trip this week, I received a letter from Capri, some finances, where I was informed, Capri is informing me that my flat was mortgaged by this builder to them, and it is criminal of them to register the flat and cancel their registration, and they are initiating some legal proceeding and civil and criminal laws against the borrowers, and they are saying that I need to take an NOC from them, and I mean, it's a very big letter. So
tell me something, Barani, tell me something. This is Monarch in Navi Mumbai.
Yeah, Monarch Universal in Navi Mumbai, and the name of the project is Monarch Brookfield. There are over 500 homeowners, and they are running helter and skelter. And I can't tell you. I mean, I was informed that they will give me the possession of my flat in 2 years' time. This is the money that I invested my lifetime saving, and I was informed that in 2 years' time you can rent the house and go ahead and be happy about
Aditya Pratap, this is appalling behavior from a developer who's obviously double mortgaged something that he has sold to somebody else, not taken an NOC from the person he has borrowed money from, and created this mess that will make any average home buyer. Nobody wants to receive a notice from a third party you have never met saying that your home is actually mortgaged with me and I'm going to now initiate criminal proceedings against you for registering something without receiving an NOC. What should she do now?
First of all, assuming that the builder has already registered the flat in to someone else, it is a plain and simple case of cheating under Section 420 of the Indian Penal Code. In such a case, the proceeds of the crime can be recovered by the police, deposited as muddebal with the magistrate, and then returned to the rightful person, which in this case would be the money and you, the home buyer. Also, there is one more hidden angle to this thing, that several projects in Navi Mumbai, and I'm also sure that yours will be one of them, several projects in Navi Mumbai are affected by the CRZ regulation, and many of them are not getting occupancy certificates because of this. So it is possible that your project may also involve an issue.
But not getting an occupation certificate has nothing to do with the fact that the home was mortgaged without the permission of the buyers.
No, this is a direct case of cheating.
Yes.
And criminal penalties will follow. It is plain and simple cheating.
Right. Uday Wavikar.
Here it is an unfair trade practices straight away. They can move to the consumer court. Simultaneously, they can move to the DRT, because one of my case, Larsen and Toubro employees, I can say Vora Builders had mortgaged to IDBI. IDBI moved against them after 12 years for recovery of the money under the and they went to the DRT also and got a stay saying that they were in possession and this was not disclosed, or they were already the buyers and no fact was disclosed. So both ways, basically Consumer Protection Act also can help them by bringing an interim stay in terms of recovery from builder, or not to create a third party by the builder. They can ask an alternate flat or the market value, and National Commission has given market value as per the real market value.
So Uday Wavikar, it is not okay for a developer to mortgage something that I am paying money for.
This is a criminal offence also, as Pratap said. So both ways you'll have to move. Simultaneously, Consumer Protection Act is a civil action. The criminal procedure, Pratap has just said, that will be a 420. You have
this was a similar case that took place with Orbit.
Yes.
This was a similar case that took place with Orbit. Saurabh Chaturvedi is on the phone line right now. Saurabh Chaturvedi, go ahead.
Yeah, hi. This is a unique case, where our flat purchaser have been stuck. I had bought my flat in 2009. It's a redevelopment case. We were the new flat purchasers. My builder, Mr. Shubh Enterprises, Uday Surve, he's now gone into the EOW custody, because he had duped a lot of people. The interesting thing is basically here the society has removed this builder because he has not completed the construction for so long.
Right.
And now they have got a new builder into the project. And we guys, in spite of having the stamp duty and registration, we are now homeless. Because the new builder who's got into this project is not recognizing us.
He's not recognizing you as buyers right now. That's another terrible case. Uday Wavikar, what should he do?
Similar thing had happened to the Vaidehi Akash project, and some of the buyers have been given the judgments in their favor. The others are in the process in the Consumer Protection Act, because what has happened here is the society is also responsible, according to me, because it is the society who redevelops the entire project. Builders are like contractors. I am telling in the simple terms. Therefore, builders are not given development rights. The first builder's termination till such time the society had given power of attorney to the first builder and he was authorized to sell. So if you have sold the flat, not only that builder, according to me, even society is liable and the next builder, because Maharashtra Flat Ownership Act
So in this particular case, Saurav Chaturvedi should take the society to court?
Society, builder and the new builder. Because the new builder is also developer who is the assignee of the society, and society is the person who wants to construct under MOFA Section 2.
Saurav Chaturvedi, go ahead. You've heard the advice that Uday Wavikar is giving you right now. Take everybody to court.
Right. Can I just add up to this?
Yes, go ahead.
Yeah, it's a complete system failure. You know, where you're quoting Vedai Akash, who has been already, cases have been registered under him for EOW, and this person is under, EOW. This person has taken over our project. So you can see our plight. Both the people are under EOW for their fraudulent things. And, it's some kind of a game being played with, with purchasers like us.
Well, Aditya Pratap, can the best case scenario be for Saurav Chaturvedi to get his money back at this point? Because, hoping to get a home in this particular society might not be the best thing.
See, as I said that he has numerous remedies available before him. The consumer remedy is a summary procedure which he can quickly invoke. He can file a civil suit if he wants to give more detailed evidence. He can simultaneously file a criminal case because both civil and criminal remedies are concurrent and can be pursued simultaneously. And furthermore, there is a very fundamental principle of company law that even if the builder sells off his project company to another builder, your purchase of a flat is like a liability. So when a company is sold to a buyer, both the assets and liabilities, they both get transferred. The builder cannot de-recognize you as a buyer in any manner.
Well, I want to come back here, to the home buyers in the studio. Mr. Ramaswamy, given everything that you're hearing right now, do you have a little more hope with regards to your case?
My only hope is with the court. My only hope is with Justice Katawala. Because I have been running pillar to post. I'm not saying the police don't do anything. I've been lucky in that case. I lodged my FIR in Mulund police station and they lodged it in one day. Now it depends on the officers who are involved and they did a good job. But you must understand the police are overworked. I have been to the police station on a regular basis and they work 12 to 14 hours. So I don't think, like what you have said before, we need a regulatory body. We need someone focusing only on real estate. Because how can you expect the police who are every 5 minutes running behind a murderer or somebody to handle your case? So my answer right now to all the home buyers, straight away go to court. Now the only problem is the court, I hope the court hears your case quickly. Otherwise then I don't know what to say.
Uday Wavikar, court is still, and in spite of everything we've talked about with RERA, with regulators, with everything, and we've spent so many hours on this channel discussing each and every one of those rules, we're still at square one. Court is still our only option.
I agree with you, Faye, because RERA also is not yet fully implemented. Secondly, in RERA again, you have a loophole where the appellate court is directly to the High Court and not a central agency, where if you can languish in High Court in an appeal because builder is more capable of taking and who will do the expenses. So ultimately coming back to today, Consumer Protection Act is doing really well. Today Justice Katawala is there, as rightly he said that the judgment of Honorable Justice is something really landmark. But how many such judgments really remain? But I would say we have to form a public opinion, and I had suggested when I was on the recommendatory body of RERA that there has to be a listing of the builders, there has to be monitoring of the builders, there has to be accreditation of the builders, so that because today, as you rightly said, that even mutual fund is listed and they are protected. But why builders cannot get listed and accredited, I still don't understand. Until we do something like this, where they are accountable directly and punishable directly, I don't think, even if there are legal provisions, it will take its own course and time, and it takes its own course time. A lot of patience, time and money is involved.
In fact, I just want to update our viewers. We are given to understand that the Kamla Landmarc hearing has concluded for the day. The High Court has instructed the builder to settle loans with the bank to repay all bank loans, and also instructed the EOW, which is the Economic Offences Wing, to state all facts of the case on Monday when the case will be heard again, because the EOW is the one that is investigating this particular case. We will bring you updates of these cases right now, because these set precedents that all home buyers across the country can use. But the biggest win, of course, is the appointment of a receiver by the Bombay High Court that has said that the receiver will make sure that the developer pays to finish the project in question. This is for a project called Shimmer in Santa Cruz in Mumbai that was started by Kamla Landmarc. Jitendra Jain is on your screen right now, being taken into court and brought out of court. He's been accused of cheating. Mr. Ramaswamy, it is a long wait. What Uday Wavikar is saying is court takes a certain amount of patience. I have a very interesting
question to my colleagues here. Now, when we say you finish a project, it means you get an OC, because there was a recent High Court ruling that nobody can occupy a flat without an occupational certificate. So, which means an OC is required for every building. So, my question to my esteemed guests here is, what if a builder has not given OC for 12, 13 years? Even reputed, extremely reputed builders, like where I am living now, like Marathon, who's spread all over Bombay, he has not given us an occupational certificate for the last 12 years. So what is the remedy?
For Mr. Ram, I would say recently National Commission President Mr. Jain, Honorable Justice Jain, D.K. Jain, has passed an interim order in Vaishali Cooperative, and then the order was confirmed that till such time OC is given, all the outgoing charges which were in past, which were put on the consumers for the higher water charges, higher electricity charges, should be remitted by the builder. Builder had to remit it with the interest, and further charges till such time the OC comes should be given by him. Till such time any other action taken by the municipal and local authorities should also be remitted by builders. These local authorities were called, municipality was called, made a party, explanation was asked that what is the regularization required for the purpose of OC.
I also want to ask you, Uday Wavikar, and when a building doesn't have an OC, and there are so many people in the MMR region that are living in buildings that don't have OCs, the concern for me is that an occupation certificate is also given to basically state that this building is safe for people to live in. If that occupation certificate has not been handed out, it means that maybe the fire safety is not done, maybe this building is not completely safe. That for me is a bigger concern. Should they, for example, people like Mr. Ramaswamy who find that the building has no OC, and your society office will know that, should they be RTIing the local BMC office to find out, has an application come in? Why has this application been denied? What is wrong with this building?
I have an answer for this.
Yes.
We did I'm a part of a committee, my society, and we did get RTI. The builder never applied for an OC in the beginning for 2 years. Meanwhile, the forest area problem occurred, which was later we got it out from RTI that was cleared too. But even now he made an application very recently with modified plans. So what is happening is the builder is a problem. He is creating problems by modifying the plan, which is not legal. So now we have approached the Prime Minister's office, and we are trying to find out what we can do next.
Well, you wanted to say something, Vishal?
Yeah, I would like to suggestions from the esteemed lawyers. Like if we come across the situations where the builder is offering us possession without the occupation certificate, so what should our stance be in this case?
Various consumer cases, the consumer court has said that you have no roof to stay and therefore you have no option, and builder, it is the duty of the builder to get the occupation certificate, because he has taken full money from you, and if he cannot give goods with the encumbrances because flat is good. But my friend Pratap from the civil court will say no, it is a contributory negligence and illegality by both the sides, and sometimes court can come heavily for taking such possession, and therefore Campacola was there, and they really faced, of course the Campacola problem was different. Certain floors were not having the OC or clearance.
So basically, Uday Wavikar, if my building doesn't have an OC and I continue to live there, I should be doing something about it. I cannot 100%. Be a resident who does not take any action.
I'll tell you, up to Mahim or even further to Mahim,
Yes.
Most of the buildings now the municipality has awakened after Mumbai incident and after a lot of buildings falling down.
So I have to wrap up, unfortunately.
Yeah,
this
I'll just say
conversation.
criminal proceedings have started against the residents.
Okay, so this is what I want to end this show on. Kalra, 1 second. This is what I want to end this show on. Home buyers, know that you are not helpless. The court is now seeing your pain. Approach the courts. We will continue to push your cases here on the media. This is something that I personally will take up and keep pushing like we have done on this channel for the last 1 year. We will push until we have regulators in every state in this country. We will keep asking the questions until it's so annoying that the states have to do something about it. We will keep bringing your stories forward. But in the meantime, go to the courts, file those cases, make your voices heard. Thank you for watching.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/Magicbricks Now. And don't forget to click the like button. You can also follow us on Twitter at Magicbricks Now. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/Magicbricks Now.